My name is Anthony Santangelo. My friends call me Tony. I want to thank you very much for having me tonight to speak to you, and I want to thank Daryl and InnovativeX for allowing me to perform this presentation. Originally, when I talked to Daryl, I said, well, I'll come in and do a basic intellectual property lecture, and he said, no, that really won't work for our group because we have a lot of advanced people. So we said, okay, we'll do a little bit advanced IP, a little bit of a beginning, and I'm going to top it off with like a Letterman's top 10 list at the end to wrap it up. So as Daryl mentioned, I volunteered to be a service provider for InnovativeX. So that means that I've volunteered to provide anyone in InnovativeX with a free consultation. So think of your questions, problems, anything I can help you with. Take one of my cards and give me a call, and I'll be glad to help anybody with any of the things you're working on as far as intellectual property or any sort of business issues. As you know, I'm going to start off with the beginning, introduction. So basically, intellectual property consists of copyrights, patents, trademarks, service marks, trade dress, and trade secrets. And the usual experience I have is that an entrepreneur will walk into my office. He's just started this business, and he says, okay, here's all my stuff. This is what I do. Here's my letterhead. Here's the symbols we use. Here's the phrases we use. And I want to get all my intellectual property now. I want to get the copyrights, the trademarks, the patents, whatever we could get. So what I'm going to talk about is various forms of intellectual property, and we'll finish up with patents because that's the most important one. Now, almost all authority for intellectual property comes from the Constitution. In the Article 1, Section 8, Clause 8, it says, to promote the progress of science and the useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. Now, I'd like to bring that out because that's the fundamental law of the land, and obviously no law passed anywhere in the country can conflict with that. Because you will meet people that feel that all intellectual property should be free. So I call this the academic versus capitalist argument. So some people in academia would argue with a person who had capitalist ideas about that whether their ideas should be patented and that person should make a profit, or whether they should just dedicate it to the public and make it public. Okay, so the first thing about intellectual property is that it doesn't protect any idea. It only protects the specific embodiments of it. And another weird thing about intellectual property law is that it's almost always couched in negative form. So there's no such thing as a patent police or a copyright police. And all of the power that you get from filing intellectual property are negative things. So if you get a patent, for example, you have the right to stop somebody from making something, or stop somebody from selling something. You can stop the importation of a product, the manufacture of a product, but it doesn't give you any positive rights. There was a time when a patent was actually a monopoly, so that may be the reason why people think it gives you a monopoly. It used to be that if you came up with some new process, you would go and speak to the monarch, and they would say, well, that would be good for the realm. I'm going to give you an exclusive. You're going to be the only person that can do that for some certain time period. Now, for example, in 1558, a man brought colored glass to England. He went to the Queen, and she gave him 20 years to exclusively monetize and take that advantage of colored glass to the market in England. So that's why a lot of people now, certainly people that have less experience than the people in this room, they think if you've got a patent or if you have a copyright, then you're making money somehow. But we all know that just having that just doesn't automatically bring you any money. Now let's just talk about copyrights for just a second, and then we'll move on quickly. So a copyright is an ability to keep someone from copying something that you've created, that you've fixed into a tangible medium. So that's really the important thing, is that it has to be in some tangible medium. The difference between copyrights and the other IP schemes is that a copyright doesn't guarantee you exclusivity. So for example, if you sat down at a typewriter and you typed out a story that was very similar to, like, let's say, War and Peace, then you would have a copyright to that, and Leo Tolstoy, his heirs would have a copyright to his material, but if it was independently created, you couldn't prevent him from selling his book, and he couldn't prevent you from selling your book. So that's why there's a lot of things that are copyrighted that can be very similar. Even pictures that would seem to be identical. Some pictures that you see, two different people took a picture of the same thing at the same time from the same place. They're virtually identical, but each of them has a copyright in their own version. Another thing about copyrights is that you automatically have one as soon as you create something. It helps to file a filing with the government in case you're ever in a dispute later, but as soon as you write something or take a picture or whatever, you're protected and you can keep people from copying and taking your works. Let me give you an example. I have a client of mine. She walked in the door. She is a Buddhist nun, and she wrote hundreds of chants in Vietnamese. Now, the chants that she wrote, each one has words, so she wrote out all the words and published them in like a book of sonnets. They all have specific music, so she actually wrote the musical notation on musical paper. She hired people to sing the songs so that they sang them. She recorded them, and now she has the copyright in the songs. And there were some special dances that she had choreographed. And she recorded the special dances that go along with the songs so that they could be protected. So she went through the process of fixing all of her creations into a tangible medium. A typical one to be overlooked is dances, for example. So a lot of times people choreograph dances and they may be passed down or handed down, but they don't create sketches or videos or anything to make those dances permanent. Okay, now let's talk a little bit about trademarks and service marks. Trademarks started out hundreds of years ago when people would put a mark on their good to identify it as being their work. It became generally accepted that one craftsman wouldn't copy the marks of another, probably with a little bloodshed along the way. So this is exactly how trademarks are used now. You have a trademark and it applies only to the classification of goods that you're trying to demonstrate is yours. It can last practically forever. So the fees on trademarks are due between the 9th and 10th year. So if you have your goods, they're still in commerce, you can file an application to continue the use of the trademark every 9 years, and it could go practically forever. I forgot to mention that a copyright goes for the life of the author plus 70 years. So if you look down the line, if you're an author and you make some money on your book, even your great-grandchildren probably could still be getting royalties from the sales of that. So that's one of the great things about intellectual property, is that it protects that income stream for your heirs down the line. Now there's a couple of interesting things about trademark. Usually when you meet a trademark attorney, that's all they do, because there's a couple of interesting things about it. Trademark law can be federal. There are many states that have trademark schemes, and there's also common law trademark, because trademarks were started by the guilds back in the 12 and 1300s. So there's a lot of common law practice that's been done before these laws were written out. The trademarks are interesting because they can be any words, any symbols, any colors. They can be videos, and they can even be smells. So another peculiar thing about practicing trademarks is someone might come up to you with, let's say, the symbol that Prince changed his name to. And it may look like an ampersand plus a French horn. So you'd have to be able to search that, what are the words to describe that symbol, see if anyone else had ever used it, because trademarks is an exclusive system. If you have a trademark, it's going to be unique. And the same thing with colors. Everyone knows that your computer monitor doesn't tell you the exact correct color of things. So you would have to be adept at being able to manage colors. Like you see, like John Deere uses that special color green. That's a trademarked colors of theirs. And smells are certainly probably a special skill to being able to protect and describe and search for smells. Especially since, we have to do it on paper, not on computer. Okay, so one that's often overlooked is called trade dress. And trade dress is just the look and feel of something. It could be the look and feel of marketing materials, designs, products, services, stores, or displays. You can file a trade dress filing with the government that describes your trade dress. A good example of that would be the look and feel of like an Apple store. When you walk into an Apple store, you realize that that's the only store you've ever been in that's exactly like that. And you have to probably sit there and look around and say, well, what is it that makes it so special? The lighting, the windows, the displays, the way all the products are out on the tables. That would be a trade dress owned by Apple. And if other people copy that, then Apple would have a right to try to make them stop. Now, another very important form of IP, which we're going to discuss more later in the advanced part, is a trade secret. So a trade secret is just, when, like the name says, when you just keep something a secret, you don't tell anybody. A perfect example of that is the formula for Coca-Cola. That's they've had that for 100 years or so, and they never patented it because they don't want people to know exactly what it is. So you could go and buy a bottle of Coke, and you could see roughly what the ingredients are. You know, it's Coke syrup and corn syrup and phosphoric acid and whatever, but it's hard to see exactly what it's comprised of. But the trade secret doesn't prevent somebody else from trying to reverse engineer or duplicate your product. So if RC Cola or ShotRite or whatever comes up with their own cola, it could be the same, it could be the identical thing, it doesn't matter, because it's still not Coke. You know, they haven't gotten the brand name and recognition that Coca-Cola has. And trade secret law comes up when there's some abuse between people that are in privity. So an employer and an employee, people that are partners, people that are in contracts. Typical trade secret dispute arises at, let's say, if someone takes all the customer lists from a company and he goes out and starts his own company. Or let's say if someone took that formula for Coke and then they went out and they made their own beverage company. So it's where somebody violates a trust that they've been entrusted with by somebody else. Now let's look a little bit about patents. Patents now are a bundle of negative rights for a limited time. So, like I mentioned before, it gives you the power to stop someone from manufacturing something, stop somebody from reporting something, and things like that. If we think of patents as a product you could get from the government, there's a couple of different flavors. So there's a non-provisional patent, which is basically what we'll call the best patent you could get, otherwise known as a utility patent. But again, it's couched in negative terms. It's a non-provisional. The provisional patent is basically a place-holding application for you. It's very useful for inventors. I think the fee now for a single inventor is only about $65. You can file it with the patent office. They'll give you a number, so you can say, hey, this is my filing number. They give you a filing date. You're allowed to say patent pending. And then you have an entire year that you can just speak freely about your product. You can give demonstrations on it, talk to people, whatever. And then if you get some traction on that, you can file the non-provisional patent later on, and you'll get the filing date of the provisional. So it lets you go back and claim the filing date for the provisional patent. So it's like a placeholder. So for that low fee, you get all those benefits. And if you work really hard that first year, you can figure out if that idea is going to be worth the expense of the full utility application, which has to be within the one-year period from the filing of the provisional. So if we add a couple other products, there's a design patent which just covers just the way something looks. So a lot of times you may come up with an idea, for example, for flatware or silverware. You have a unique design. You could protect that so people could not copy the design of it, but it wouldn't cover any of the functionality. Another type of patent is a plant patent, which you can get on any plants that are asexually reproduced. A good example of that would be like a seedless orange. The story of the seedless orange was interesting. A farmer was in his citrus groves, and he found that one branch on a certain tree had all oranges with no seeds. Doesn't know why. I'm not sure we know why yet. But since that's a product naturally occurring in nature, he couldn't get a patent on it. But what he could do is he could take grafts from that, graft them onto other trees, see if he could reproduce having seedless oranges, and then he could get a patent on that. So what he ended up with a patent on is an asexually reproduced graft that produces seedless oranges. Now, this has to fit, you have to fit within certain categories to get a patent. And they're a process, a machine, a manufacturer, or a composition of matter. We added the asexually produced plants and design. So altogether, that's 6 areas to look at. You can't get a patent on anything that occurs in nature, even if you had to put a lot of work into finding it. For example, let's say you were the first person to discover oil, you drilled a hole 2,000 feet deep, you found oil, you still can't get a patent on that or anything else discoverable in nature. You can't get a patent on a perpetual motion machine because they feel that perpetual motion machine has no useful purpose. You can't get a patent on any plant or organism that's already alive. You can't get a patent on a theorem that represents a physical process like E equals mc squared. You can't get a patent on a mathematical equation like the Pythagorean theorem, which is a squared plus b squared equals c squared. But you could, if, for example, you created a calculator that said, okay, this calculator will calculate the diagonal of a room. If you put in the 4 sides of the room, it's just going to use the Pythagorean theorem to find the diagonal of the room. That would be patentable, but the theorem itself wouldn't. You can't patent anything in America that has its only purpose as something criminal. People have tried to patent things like safe cracking devices and things like that. You can't get a patent on anything like that. And you'd be glad to know you can't get a patent on a nuclear weapon design. So the government has got an exclusive on patenting nuclear weapons. Now the requirements for a patent are, besides fitting into one of those categories, it has to be new, useful, and non-obvious. So when they say novelty is the concept of being new, it's got to be really, really new. So it can't exist anywhere else in the world, either patented or not patented. It can't have been in use or described or published or patented anywhere in the world in any language. So our Patent and Trademark Office has a huge amount of materials in all different languages. They have access to all the patents all around the world. So when you send them a patent, they're going to find out if that has ever been in use anywhere else. There's also what practitioners call it like the secret. They're all of the patents that are ahead of you in the patent office that haven't been published yet. They also might be. They also might prevent your invention from being patented because they're just ahead of you in the patent office, and that's all a secret. There's no way for you to search that. So even if you do an extensive search, sometimes you may not find out until you hear back from the patent office after you make an application whether or not that your product has already been applied for. We discussed usefulness. Almost anything is useful, but for example, they like to pick on perpetual motion machines. Some perpetual motion machines are very beautiful and fascinating, but you still can't get a patent on them. One major stumbling block is what they call non-obviousness, another negative reference. So to think of this concept, the patent office invents an imaginary person. They call him the person having ordinary skill in the arts, or faceta. So practitioners just say faceta. Now that person knows everything about your field of invention, right up to the point where you create your new thing. So the problem there is that your invention has to be something that wouldn't have been obvious to somebody who knows everything about that field and back. One good thing about it is that when you're writing up a patent, you don't have to. There's a lot of times you can just use a very short phrase like such as known to a person having skill in the arts. So that would mean you don't have to say, okay, we're going to put two things together, and they could be glued or screwed or nailed or riveted or something. You don't have to say that. You could just say, as would be known to a person of skill in the art. But this is a major stumbling block a lot of the times, because it's hard to argue that something isn't obvious once you've shown somebody all of the previous art material, and then you've told them what it is and how your thing works. So when you're fighting to get a patent, it's called a prosecution, and it involves a lot of back and forth with the patent office. And a lot of it is trying to teach them how the thing that you came up with wouldn't have been obvious to that mythical person. Okay, well, we have to move on a little bit. The advanced topic that I thought we'd present is, should you get a patent at all? A lot of people have said, is it worth it getting a patent? Should you not get a patent? And there is a lot of articles and discussions out there. So I thought I would attack that a little bit differently than some of the other things. Again, it's an advanced topic, and one of the problems that we have is a lot of times the information inventors have is urban legend, really. So a lot of times you'll hear about someone stealing someone's invention. The federal government has certainly stolen inventions. Most of the firms in Detroit have stolen inventions from people. And that's the one thing no inventor wants, to put his life's work into something and then have, like General Motors, just take it and use it because they know that you couldn't possibly muster the resources to fight them about it. Other urban legend are quotes from people. For example, Henry Ford once scoffingly said that he would never pay any inventor a royalty, and he had suggested that he basically invented everything there was to be invented for the automobile industry. So that sometimes has an effect of creating the urban legend that you just can't sell anything to the car companies. But I think, as we discussed before with the idea of a trade secret, every practitioner should mention to an inventor and ask them, would your idea be better marketed if you just kept it a secret? Like Coca-Cola, should you just keep your idea secret and not sell it? So besides that, we're going to look at a case. When Darryl gave me a call, there was just a case decided in California about a company called Sequinom, which had their patent invalidated. And it's a good case for us to discuss. Sequinom developed a test for being able to tell whether an unborn child had Down syndrome. So, as you know, the incidence of having a child with Down syndrome increases tremendously with age. So for a woman at 20, her risk is 1 out of 1,600. But by 25, it's 1 in 1,300. By 30, it's 1 in 1,000. At 35, it's 1 out of 365. By 40, it's 1 out of 90, and by 45, it's 1 out of 30. So at the present time, they screen all pregnant women for Downs, but it's only an indication, it's not a positive test. So from here backwards, to find out if a woman had Down syndrome, if the baby had Down syndrome, they would do an amniocentesis, which is take some of the fluid from the mom's uterus and test that. One of the problems with that is that test is expensive. It's about $1,900, and 1 out of every 300 tests will result in the fetus automatically aborting. So that rate, just the rate of the test, is 1 out of every 300. So Sequinom was very clever, and they figured out that some of the fetus's DNA is floating around in the mom's blood system. So they take a sample of blood from the mom, they sequence her DNA, they sequence the baby's DNA, and they find out if the baby is going to be a Down's baby. Basically, a human being has 46 chromosomes that are arranged in 23 pairs. Most Down syndrome is called trisomy 21, which is where the number 21 chromosome has 3 chromosomes instead of 2. So they could figure out from replicating the DNA, chopping it up in bits and just adding it up, if the baby was going to have Down syndrome. So one problem is that since the clinical test was $1,900, Sequinom marketed their test for $1,900, even though it was just a blood test. That made a lot of people angry. And there are other companies that were willing, able, and ready to do this test also if the patent was invalidated. So what happens is there was a dispute between Sequinom and another company, and the Sequenom patent was invalidated. So this followed a decision in June of this year from the Supreme Court in a similar case involving a company called Myriad Genetics. You've probably heard of them because they do the BRCA1 and BRCA2 genes for breast cancer. And famously, Angelina Jolie had that test, and then she decided to have surgery. They were charging about $3,000 a test. And they did have their patent invalidated also. Justice Thomas wrote that groundbreaking, innovative, or even brilliant discovery does not by itself satisfy the criteria for patent eligibility. So the Supreme Court basically looked at the way that Myriad Genetics was doing the test and said, well, you're just looking for something that's already in nature. And then you're saying, okay, there's a little extra chromosome, or there's a certain gene on the DNA strand. They're saying that that follows the rule that if you find something in nature, you can't patent it. So for Sequenom, that may be something for us to consider if they should have just kept the process a secret and not told anybody about it. So then if they kept the process a secret, you would send them a test sample, they would perform a test on it and just tell you whether you had a baby with Down syndrome or not. So if you look at the classifications for patents, which is how I looked at, some of them lend themselves to being secrets and some of them really don't. So a process like that, where you run it, you start the company, and someone sends you a sample, you perform it, and you give them a result, that's a good candidate for just keeping it a trade secret. Besides a process patent, a manufacturer is also a good candidate. For example, if you were the person who invented polypropylene or some type of plastic, polyethylene, you could sell the plastic, but people would have a very hard time figuring out how you made the plastic just from getting the sheet of plastic. Some other things might be harder. For example, if you created a machine, machines have a wide range of being able to be copied or not. And you could also change the way that you commercialize it. So for example, my example was a cotton gin. So Eli Whitney invented the cotton gin, and then he marketed the machine. Instead of doing that, he could have just installed the machine in his business and said, okay, everybody bring me your raw cotton, and then I'll process it, and then all they'll know is that processed cotton came out of the other door. They would have no idea how he did it. So if you had a machine that performed a process that produced a finished product that people wouldn't be able to reverse engineer, that might be a good way to do it also. It's also, it's similar to a miller when you have flour milled. You take the grain to the miller, and he makes flour out of it. And the funny thing about the patent system is that it was created to encourage innovation, because most people, if they know they're going to put a lot of time, imagine how much time and money Sequenom and Myriad Genetics put into developing those tests. And those tests were very, very recent. So one was only out for 2.5 years, and one was only out for 3.5 years. And now they've been invalidated, and people can go and read their patent and see exactly how to do the test that they got the patent on. So that's the patent system. It'll encourage innovation if it protects people's ability to earn money on the research that they do. Now, some other comments on that. For example, consumer products. If you invent a consumer product, you're going to have to demonstrate that to people pretty early on in the process. So that would, to me, that would demonstrate that you should need a patent on that. So I think in my notes I say, well, I probably just managed to confuse everybody. So let's see if we can make just a roll out of thumb out of that. So consider using a trade secret if the intellectual property is difficult to reverse engineer by just examining the finished product or result. This more readily applies to processes, manufacturers, and asexually reproduced plants. You may need a patent if your industry requires it, if you can't get any funding or a manufacturer to use it unless you have one. Or in the case of genetics, the field is progressing so quickly that there's someone right nipping on your heels to get that test as soon as they think of it. Now, compositions of matter might be a little bit harder also. For example, like blacktop road material would be a good example of a composition of matter. It would seem that you could probably readily reverse engineer that once you saw it. So probably a patent would be good on me on that. And from the cases that we saw, you should be wary if there's an argument that could be made that your product could be a naturally occurring substance, and if there's a strong public interest in invalidating your patent so that the public can receive a much cheaper test. Machines would seem to be a less likely category, but it depends on the complexity. So, for example, if you have like the cotton gin, if you could use it to perform a process and not show people, that's a good way to commercialize it. Or if the machine itself was extremely difficult to engineer, such as a chronometer or like a fancy Rolex watch or something like that, that would be very hard to duplicate. And now I want to do a top 10 patent insights. Okay, number 10. Sun Tzu once said, "Know your enemy, know yourself, and you'll be victorious in 100 battles." So the number 2 reason for a person not meeting their goals after the fear of failure is the fear of success. So I just wanted to say, just think about that and think if the fear of success is one of those things you need to think about so you can eliminate that. Number 9, don't believe in industry averages. For example, Facebook alone made $260 billion for its investors, and if you average that into all of the deals that are done, it seems like it's a much more lucrative industry. Number 8, keep your priorities in order. I know a lot of inventors work 24/7, 365 on their ideas. So it's a good idea to keep in mind, make sure you're healthy, you're eating the right foods and exercise, you keep your relationships with your family. Don't forget to keep your moral compass round. Number 7, it may do a lot more for the world if an underprivileged person learned how to paint a room than if we come up with the next white-colored doodad. Number 6, if you have any 35 U.S.C. 102 barring events, those are if you sell your product, if you describe it in a printed publication, if you offer it for sale, that starts a time clock ticking, and you have to apply for a patent within 1 year, otherwise it'll be dedicated to the public. So I would say get a calendar, and if you've ever talked in public about your idea or tried to sell it to someone, put that earliest date on your calendar and make sure to file something within the next year. Number 5, protect yourself as much as possible, but don't be afraid to talk up your invention. Someone once said, you don't have to worry about people stealing your idea. If you had a great idea, you'd have to beat people over the head in order to get them to notice it. Number 4, develop a 2-minute elevator pitch, so whenever anyone asks you what you do, you can give them a 2-minute pitch about your idea. Number 3, be cynical and skeptical about statistics or opinions in this area. The Patent Office proudly proclaims that they issue 1 million patents a year and that 2 million are applied for. And this would seem to make you think that they clear half of their workload in a year, but they really don't. They have a massive backlog, and in fact, on patents that are applied for by an attorney, only 40% ever issue as a patent grant. Number 2, avoid lottery fever. I get the impression from venture capitalists that they don't want to get out of bed unless there's a 9-figure deal for them. Remember that there's very few deals that big. I've heard the number 38, so I think there have been 38 deals that returned more than $1 billion for the innovator. And lastly, number 1, which is what I tell all my inventors, if it's to be, it's up to thee. So it's estimated that invention promotion companies earn $200 to $300 million a year off approximately 25,000 inventors, and that perhaps 2/3 of this is fraud. So don't assume that you can pay a company to do anything you could do, and you may not be even able to pay one of these companies to do some honest research on an hourly basis.
Lately, at least in my conversations, the conversation du jour seems to be about business process patents, and it's really murky to me. I don't understand it.
Well, theoretically, you can get a patent on a process, and they started issuing those business business process patents pretty late in the patent office's existence, and I know a lot of them have been struck down. So I don't really know much more than that about it. If you have an idea for a process, it's certainly still, subject matter that could be patented. But some of them, I know Amazon had a patent on a one-click process, and that was a great patent because they could make sure that no one else could order. No other site could take an order in just one click. So that's where having that negative power was very good. So they could make sure that whoever you bought from couldn't use a one-click process.
So in your opinion, they're difficult to enforce?
There's such a wide range of scenarios that could cover that. So I'm not really sure what scenario we would be thinking about.
Like in the example you used, like the one-click. Sorry, I'm not trying to set an argument.
No, sure.
But okay, so like the one-click, like, is that really unique? I mean, can anybody put the software up and have one click? That seems.
Well, whenever there is a patent litigation, first of all, I think someone said the average litigated patent case costs $1 million per side. Individual people have a hard time with enforcement like that. But you have to think of, well, what are the odds that my idea really is going to be stolen by somebody? So I think the important thing is to just keep promoting your idea, and do whatever it takes to either get it out in the market or raise the money so that you can do it.
You had discussed you'd said in regards to urban myths about we'll just say the little guy who has a patent on something, and a big company comes along and they decide, we're just going to make it. What would be the scenario there? Can you just explore that a little bit further about what kind of rights a person has who has a patent, who just say is of a modest income, to be able to enforce that patent against a much larger corporation?
Well, that's one of those things. There's a lot of stories like that. Certainly, I know that General Motors has perpetrated that a number of times. And one story that I read that I really liked was the man who invented the nuclear magnetic resonance machine. He invented it, and immediately Siemens and General Electric basically stole all his patent material and made their own. And so he brought suit against them until he ran out of money. And he just got tired of doing it. But luckily, he had an energetic grandson who took the whole package and started shopping it around to patent attorneys to see if they would do it on a contingency basis. So he finally found one of the best firms in America, and they brought suit. And before the court case was over, Jack Welch himself called. They had a meeting. Jack Welch waived a check for $80 million and said, here's $80 million, but I get those 2 patents. And they said, no. So then it turned out that they won the case, and General Electric was liable for like $170 million, and they didn't get the patents. So then everyone else, Siemens and Westinghouse, everyone else that had been doing it, just fell right in line and started paying them a fair royalty. So there is an example of the little guy, kicking Jack Welch around.
In the case of a dispute like that, when there's a dispute occurring, is the individual who holds the patent able to still produce whatever is patented and continue with that, or is it frozen and everything that is related to that patent frozen?
That's a good question. Let me just think about that for a second. The getting an injunction like that to make somebody stop, it has a pretty high standard. In fact, before you can get an injunction, one of the standards is that you have to prove that you would be likely to prevail in trial. So it's very hard to get one of those too. So I would probably be business as usual until the case was decided.
Okay, makes sense.
This is going to sound like an obvious answer.
Okay.
But try to read into this. What's the impact to first to file starting the clock? Do you know what I mean? Like, is this going to be good for the U.S. and good for the inventors in this room, or how does it affect if you got history.
Well, you know, that's a lot of speculation. It's sort of like, I was telling Daryl earlier, I have a friend of mine who doesn't like the current health care plan by the president, and he pretty much assumes that all these terrible things are going to happen. So I think that the first to file, I sort of like it, because it's just like when you watch the movies in the old days. You see the two miners are digging in the stream. They both find a nugget, and they look at each other, and they both run to stake a claim. So that's what we're going to be. It's like when that guy finds that nugget, he better run to the patent office and file it, because they're just going to say, okay, what was the date yours came in? What was the date yours came in? And that is the way really almost the entire rest of the world does it too.
Okay.
So now if we have a dispute between two inventors, like, you know, previous to that, they would have to prove that they were the first to invent. So you could just imagine how much testimony you have to take, how many notebooks you have to go through before you can figure out, you know, who invented it first. So this takes a lot of burden out of the system too.
Simplify it, right?
It's like your deed on your house. You know, a lot of times unscrupulous people sell a house over and over again, and the first person that registers the deed at the county office gets the house, and then the other person, all they have is a claim against the person that was sold the house multiple times.
I have a colleague that has a product that she's brought to market, and someone who has a dissimilar design patent, there's a patent troll, an attorney that does what you hailed as the worked on contingency, and under the idea that it's going to cost $1 million per side to protect, what they're doing is kind of they're saying this is the same as this, and they're asking for an obscene amount of money, and trying to block her, even though they only have 2 more years left in their patent anyhow. But she's made reasonable attempts to resolve it. They're way off the deep end as far as the money they want to take. Is there usually, I guess in military terms, a back door that you can stop something like that, or prevent, or
Well, not at the present, but you know, there's probably going to be some new legislation in that area, because so many people are so abusive with that, and I could see that they'll probably write some legislation that'll help those people out. But there's really, the only thing you do is go to court and spend the money and see what happens.
What was the name of that company that did the test for the unborn child with Down syndrome?
Sequinom.
How do you spell that?
I think the beginning is like sequence, S-E-Q-U-E, and then N-O-N.
N-O-N?
N-O-N.
N-O-N.
Okay, thank you.
Sure. And that was just October 30th, that was decided by the California District Court.
In patent law, I guess, especially product manufacturing, I mean, what are some of the international ramifications and considerations when you file a patent in the U.S.?
Okay, well that's a good question. There are several tracks now. There's a thing called a PCT, a Patent Cooperation Treaty.
Okay.
So there's a track that you can follow if you want to have your patent be patented in a lot of other countries. So you could designate it as an international application when you file. And so it's basically, they've decided that the entire world can accept pretty much a standard application, but there's probably maybe, let's say, 6 different languages that you might have to have it translated into depending on which countries you want it to go to. And then, so it goes through a common international process, and then a sort of a streamlined process for each of the countries that you designate. So it's technically possible to follow that PCT process and get your patent into a large number of countries at the same time. It's very, very expensive.
So, and that's the only way it works. You can't do it like, you don't go independently from country to country. You would just file.
You can. You can.
Or you can.
Yeah. But there is the PCT process is a lot more streamlined, because then you may, you know, if you want to get, you may be able to translate it into French, and that may be good for the EU. And then, you have to look and see what, like maybe, I'm not sure if Russia is a member. So, and I know Japan is a member, so you might have to get it translated into Japanese. So a lot of those patents that fall out because they, I think they get tired of translating this stuff. It's probably really expensive. But when you look at the Gazette, a lot of the patent trademark Gazette, a lot of the times people just give up when they're noticed about, yet another translation. So I'm guessing that have a patent translated is expensive.
Like in the real world, as it relates to product manufacturing, the technology is a whole different deal. But how does it work? Do people actually even do it? If you have a product that sells for $500, does anybody bother even patent it internationally? Well, I consider, I have stuff manufactured in China, like everybody. And that's always like some of the designers I work with. They're always like, "Well, let's get it patented in China." Like, you have no idea. First of all, but what do people really do?
Well, there's a lot of non-patenting issues with that. So, people have always worried that things that you have manufactured in China might be counterfeited or duplicated for sale.
They are.
And so there's strategies people might have, like let's say if you were making a shoe, you might have all the different parts made by different people, but then have someone in Guatemala glue the actual shoe together, or something like some scheme like that, so people don't have an idea what's going on. But I know that I've been involved with companies. As soon as they sold a couple of units into like Hong Kong or China, it was just copied instantly.
My question is more, if you have an idea, but it's very much in the infancy stage, and you're still looking for people to work together with, you're not really at the point where you can file a patent. How do you protect your idea when you're in that development stage, and you need to identify people that maybe can help with the design or the technical details, engineering it, before you get it on paper and filed?
Well, that's a good question. So, you would certainly try to get one of these done, one of these confidentiality agreements. And it sounds to me like for the things that you mentioned, you could probably get most of those people to sign. Like anyone that's going to do any design work for you, whatever, they're going to sign it for you. But there's probably, that would limit, let's just say, to a great extent the number of companies that you could approach, because a lot of companies won't sign them. So they won't sign confidentiality agreements. So then your result is to either just tell them or to give up on them. And that might be one of those events where you tell them, but you write it on your calendar, and you know that starts a one-year clock ticking. And if you can't generate some interest within the next year, you have to either file something or not pursue it.
Right. But you have to have something that's fairly technical, or you actually talk about how this works to patent it. You can't just patent like, oh, I'm going to have something that's like this that I haven't figured out the technical aspects of it yet.
Exactly. So an invention is basically an idea plus the reduction to practice.
Right.
So that reduction to practice, that could be an actual functioning thing, or just the completely developed idea of how it's going to be made.
Right.
And the patent application is basically how to make it and use it.
Right.
So,
Okay. So if you need to work with an engineer to help design those aspects, then you hopefully can get them to sign a confidentiality, and that should protect you from that aspect.
you should be able to get, right, from any of those people that are helping you, should be able to get it from them.
Okay.
Well, that's the thing that comes up a lot, because the best thing, a good patent attorney or good patent agent, when you tell them an idea, you should do at least some preliminary search to see if anything reads right on your idea. And if it does, you should work to design around it. So if you go, let's say you have a partner, and you find out that the thing that you invented, we use the phrase reads on, it means someone else has exactly the same claims, then you might embellish the device so that it has more new matter in it. But then anything that other person contributed would make them a co-inventor. So then you hear from a lot of these invention promotion companies, and there's like horror stories where they go to the invention promotion company, pay them thousands of dollars, and then when they file it, they make themselves co-inventor if they had any suggestions at all for the product. So is that sort of what you were
Yeah,
getting
that
at?
gives them the right to license or make anything without your approval.
Right,
Is what I wanted to.
they could do whatever, right, they could act, either one can act
So you
independently.
can really take it in the teeth. If you work with an engineer and you're going to pay the engineer, most of them will go ahead and sign up, no problem.
Yeah.
But if you're going to work with a buddy of yours, and you expect to be co-inventors, what you should do is have them sign, so they assign their rights to you for the right of a dollar or whatever, because you want one person to own the rights to the patent. Otherwise, you could exclusively license it to company A, he could exclusively license it to company B without your permission, even if he only does one claim. It contributes to one claim.
That's a good comment.
My question is, I've had so many different times, people have told me, you should do a provisional patent, you should do a full utility patent, a service patent. I've talked, and I basically want to find out, as soon as I come up with the idea, is it best to just sketch it out, draw up the summary of it, and apply for a provisional patent? At least gives myself an edge to when I go talk to investors, because right now I'm chasing the investors, but I understand that if I had the patent pending via the provisional, they would all come to me.
Well, I think the patent system has a certain flow built into it. So, for example, like one of the things I said is that if you make your idea public, you've got a year to file the patent. So the patent office is assuming that you're being pretty vigorous. So then you have a year to file, let's say, a provisional, and then you would have a year from then to file a utility patent based on it. So that gives you like 2 years. Well,
From the original time that I came up with the idea, it's been 7 years.
but you didn't disclose it to anybody? So,
I haven't disclosed 100% of it. I've
Well-
talked about,
yeah, so if you're keeping it confidential, that doesn't start any clocks ticking. So you can have an idea and keep it, confidential your whole life.
Good, thank you.
Then it becomes a trade secret.
Yes, Tracy, have your cards up there in the table?
Yes, please.
Okay.
All right, Mr. Centeno, thank you very much
Okay,
for
thank
presenting
you.
to the principal.